Hello, folks. Welcome to the final episode of Spilling Tea for today. Today, we are going over the third part of the trial of the Judge Rotenberg Center back in 2012. This is the part from April the 18th, 2012. Now, warning, you're going to hear throughout the coverage of the trial that we will be reading through from this time explicit. Basically, you're going to hear about torture. Blah, blah, sorry. Kind of brain dead. Alright, again, as always, this is by Shane Neumeyer. The trial over restraint and electric shock of Andre McCollins at the Judge Rotenberg Center continued for a full day on the 13th of April and included the conclusion of the plaintiff's case alleging medical malpractice and beginning of the defendant's case to refute this claim. In attendance were the plaintiff, Andre McCollins' mother, Cheryl, and defendants Dr. James Riley and current JRC Director Robert Van Hine, with the third individual defendant, the JRC founder, Dr. Matthew Israel, still absent. Gee, I wonder why. Dina Trinelio, member of the disability rights organization TASH and longtime opponent of the JRC and its practices, was also present in support of Ms. McCollins and Andre. The cross-examination of the plaintiff's expert, Dr. Mark Whaley, continued with attorney David O'Connor for defense, delving into Andre's experiences at the residential programs that he attended before being placed at the JRC. The point of this, evidently, was to cast doubt on Cheryl McCollins with regards to her credibility and her effectiveness as an advocate for Andre. Among other things, through the defense's line of questioning, it attempted to show that Mrs. McCollins complained frequently, that she and her son were not all that close, as evidenced by the fact that he called her Cheryl while he called his grandmother Mommy, that she was unhelpful in establishing continuity of Andre's treatment by bringing him home too often and refusing to discipline him as needed. Gee, really? You didn't torture your son, so it's all your fault, and he doesn't like you anyway. And oddly, that she was homophobic, in that she demanded Andre to be placed in dorms only with straight boys his own age after he was molested by an older student at the first residential program he attended. Andre's sexual abuse at this facility, which is one of the Devereaux's residential programs, was an issue that quite possibly cut against the defense in the end, because of the connections that could be and were drawn between it and the events of the 25th of October 2002. Dr. Whaley told the plaintiff's counsel Benjamin Novotny and the jury on redirect the position that Andre was restrained and was very reminiscent of sexual assault, especially with members of the staff straddling him and at one point removing his pants in order to put him in a diaper. Jesus. This, according to the witness, put Andre at risk for re-traumatization. Furthermore, PTSD is a thing. Furthermore, through cross-examination, it came out that, following his sexual assault at Devereaux, Andre began to speak incoherently as a result of the trauma he experienced there, a behavior that resumed after what happened to him at JRC and continued ever since. While the intent of the defense counsel in addressing Andre's sexual assault was likely to cast doubt on whether the harm to Andre was actually caused by his experience at the JRC, the plaintiff used this information to show how JRC may have in fact compounded his trauma when they should have known better. Yeah, really, you think? Another issue that came up in both Dr. Whaley's and Ms. McCollins' testimony in an attempt to discredit the latter was an incident where she complained to the JRC about a number of marks on his arm that, at the time, she believed to be burns from the use of the Graduated Electronic Decollator, GED, but later described as bruises. Yeah, it causes bruises too, dumbasses. Jeez. The defense was taken on this was that Miss McCollins, a registered nurse, should have been able to tell the difference, and this was just another mark against her credibility as a witness. While Miss McCollins did not remember at this point what that injury to Andre in fact had been, Dr. Whaley pointed out that a burn can, in some instances, look like a bruise and can be confused with one, especially when they're healing. I would know. The discussion of whether Andre was psychotic on the day that he was restrained and repeatedly shocked, I really don't see how that has bearing on anything. My mom has dealt with people who were having psychotic episodes. She did hospital trained regular restraints. She didn't need to electroshock them. She didn't even need to harm them, and they worked all just fine. I would know. She's told me. There's documents. Just saying. And what, if any, effect this should have had on the JRC staff decision to use aversives on him continued in the cross-examination of Dr. Wiley. The witness maintained that although Andre was only properly diagnosed at the end of the day, he had been psychotic, and thus unable to learn or benefit from the electric shocks throughout the entirety of the incident. Mr. O'Connor pointed out that it was inconsistent that he would criticize the JRC staff for failing to effectively communicate to Andre while he was being shocked, as he also maintained Andre was not able to understand what was being told to him, which Dr. Rayleigh refused to give answer to when posed to him as a yes or no question. Good for him. Elaborate. It's needed in this case. Seriously? In support of treatment currently used at JRC, Mr. O'Connor brought up the literature on the use of aversives authored by Drs. Israel and von Hein themselves. Peer-reviewed. Really? I'm just going to read literature from the people that are on trial. God. Really? By contrast, he pointed out that Dr. Whaley had never written nor published anything on the subject of behavioral modification, much less aversives in particular. Gee, I wonder why. Could it be aversives are abusive? Mr. O'Connor also asked the witness whether any studies had been done that proved psychotic patients could not, in fact, benefit from the use of aversives. Yes, you can benefit from abuse. You heard it here, folks. Dr. Whaley said that had not been any credible recent literature on the subject. It would be cruel to the point that no reputable organization would fund such research to even find out if it were possible. Thank you! Furthermore, he said the literature from 150 years ago would tell you that such treatment was ineffective. Again, thank you. When asked by Mr. O'Connor whether we had advanced since then, he simply smiled and said, I hope so. Many of the arguments that the JRC brings up regularly in a more general defense of its methods and practices came up in the course of Mr. O'Connor's cross-examination. Once again, the attorney referenced serious and sometimes permanent side effects of psychotropic medication such as Risperdal, which Andre had been taking prior to and after his placement at the JRC, as the only alternative means of addressing Andre's severe behavioral problems. It's not. By the way, in case anyone's wondering, it's not the only option. It's not the only other option either. God, I hate people. Okay, moving on. He also referenced documents that showed Andre had been subject to restraint at other residential facilities prior to his placement in the JRC in response to his severely aggressive behaviors, which no other program had been able to address. Furthermore, in an argument that made in a number of JRC writings, so let's take it a step further and shock him? Jesus Christ, what's wrong with people? Mr. O'Connor got Dr. Whaley to agree to the statement that sometimes doctors have to do things that harm their patients, and compared to the use of aversives to procedures such as surgery or dental work. Sometimes you have to go through a lot of pain to get results, he argued, to which Dr. Whaley agreed in principle, if not the actual application as it's applied to the case. What is wrong with these people? It is called and do no harm. It is literally in the freaking doctor's oath to not knowingly do and intentionally do harm to your patient. Electrocuting them for misbehavior is harming your patient. This is like straight out from the abuser's playbook. Jesus Christ. During testimony, Dr. Whaley revealed, after being strongly criticized the day before by Mr. O'Connor for not having watched all the video footage nor read all the relevant documents on Andre's treatment at the JRC, he had, in fact, reviewed the entire record. After doing so, he said he had not changed his opinion on what happened to Andre, and in fact, he was, if anything, more convinced that the JRC's actions amounted to a gross neglect of duty. At the close of the cross-examination, Mr. O'Connor asked whether his failure to review all available information prior to the trial could similarly be considered such a gross neglect to duty, to which Dr. Whaley firmly answered no. After cross-examination, Mr. Novotny returned to the actual events of the 25th of October 2002 on redirect examination of the witness. Through testimony, Dr. Whaley expressed that at the time of the first shock, Andre was not a threat to himself or anyone else, and was in fact too unresponsive, too out of his senses for the shocks to be justified on the basis of either emergency measures or methods of behavioral modification. In fact, when asked to remove his coat, Andre did not even outright refuse. He simply remained unresponsive to the request. It was only once he was shocked that he moved, falling off the chair and hiding under his desk, in which Dr. Whaley characterized as attempts at avoidance and survival, as he must have perceived staff as attacking him. Gee, really? You think? From there, the JRC staff and individual defendants made a series of bad decisions, which included not diagnosing his psychosis before the damage had already been done, not recognizing that his behavior may have been a result of medication withdrawal, and not realizing the potential for and taking steps to avoid re-traumatizing Andre based on his sexual abuse history. In particular, he said putting Andre on the restraint board was a terrible idea, and that it committed them to a specific course of action that prevented them from effectively diagnosing and treating Andre. The redirect also allowed for a brief exploration of Andre's behavioral plan in the JRC in general, which included the other behaviors for which he could be shocked. In addition to aggressive behaviors, the GED could be used in response to major disruptive behaviors, such as yelling, screaming, and swearing, non-compliant behaviors such as one referred to as blatant no. God, this is... See, autistics and ABA are taught to say no, yes to everything. Can you think of what the problem with that is? I'll leave that to you. And behaviors defined as inappropriate, such as hand clapping, talking out of turn, nagging, and talking to himself. When asked whether some of these behaviors were common in autistic people, Dr. Whaley answered yes in spades. Thank you. Mr. Novotny also attempted to delve into the issue how informed the consent to use the aversive truly could have been based on the information provided to parents and guardians of the prospective JRC clients, which included questions on the permanent side effects of aversives and prior deaths at JRC. The defense objected to this, which resulted in a sidebar discussion between the parties, and the judge then opened argument outside the presence of the jury over whether this evidence should be allowed in. The defense argued that this informed consent argument was new to them. It had not been properly raised in prior documents leading up to the trial. Plaintiff's counsel, on the other hand, pointed to mention of it in the pretrial memorandum. With regards to substantive issues, the plaintiff insisted that it was incumbent on the JRC, As the only program to use adversive in the way it does, and thus the only real gatekeeper to provide all relevant information, including that on deaths and injuries resulting from its treatment. The defense counted that the deaths that had happened at the program had not been the result of adversives. Really? Really, I beg to differ. That's not what the court documents found on those other cases. We've been through them on this channel. And this information was irrelevant. The judge tentatively and then later permanently prevented the plaintiff's counsel from exploring this issue any further. What bullshit. Bullshit. If you are taking your kid to a center like this, wouldn't you want to know if there had been deaths that were caused? Of course you would. In the very short recross examination, Dr. Riley's defense attorney sought once more to establish that the use of adversives may have been appropriate on Andre, even if he had been psychotic at the time. In particular, he pointed to a part of Dr. Whaley's own deposition, which would seem to suggest that he found the use of shock and restraint to be appropriate, at least initially. Dr. Whaley disagreed with this characterization of his response, saying instead that the JRC staff of Andre had quickly gone from appropriate to being torture. Following Dr. Whaley's testimony, Ms. Collins returned to the stand to offer further testimony from that she had provided on Tuesday. Specifically, the jury heard about the days, months, and years that followed of Andre being restrained and shocked at the JRC. When Ms. Collins had showed up at the JRC and watched the video, she asked Dr. Van Hine why this had happened, to which he responded, as the defense has maintained throughout the trial, that Andre had tensed up, which was a targeted behavior. The fact that his muscles tensing up due to the fact that he was being shocked, and this is what happens when you're shocked, is considered a targeted behavior that was worthy of more shocks. It horrifies me. It should horrify you. She told the jury that in dealing with the aftermath of the incident, she felt as if the staff at the JRC cared far more about the paperwork than they did about Andre. Mrs. McCollins went on to tell how Andre was very scared and frequently quiet while in the hospital following his being removed from the JRC. No one could use their cell phones around him, nor use remote control for the television because of their resemblance to the GED. He would reportedly begin to cry and repeatedly say no if he so much as saw a phone. He was unable to be left alone as he wouldn't eat, go to the bathroom, or otherwise be able to take care of himself. And Cheryl and her sister stayed with him around the clock while he was at the hospital. Even once he returned home, he required prompting to do anything, and largely stayed in bed, and would call out his mother's name all night long for nights on end if she wasn't present. Since what happened to him at the JRC, he has lost the ability to speak coherently, and has entirely lost interest in many activities he used to enjoy, which included rollerblading, basketball, and board games. As far as his medical condition is concerned, following the incident, he required treatment for an ulcer over a number of months, and saw a number of medical doctors and psychiatrists. Whereas prior to attending JRC, he was on a single medication, the antipsychotic Respiradol. He has since been put on numerous others, including several additional antipsychotic and other psychiatric medications. Has been in another residential program in Brooklyn since 2006, and at this point, according to Ms. McCollins, has no prospects of living independently in the community. On cross-examination, the lawyers for the defense focused more on what happened before Andre's placement at the removal from the JRC. In this part, this was used to show Andre had in fact exhibited aggressive behaviors, which had included striking or attempting to strike Ms. McCollins in the face at one point and assaulting members of staff. According to the testimony, Andre had experienced hallucinations that ordered him to harm his mother and had engaged in serious self-injurious behavior. The defense specifically asked McCollins about Andre's last visit home from the JRC before the incident, especially in regards to the behaviors he exhibited at the time and her response to them. She admitted that his behaviors were bizarre, More bizarre, in fact, that they had ever been before in her estimation. Gee, I wonder why, with you shocking him all the time. But he had not been aggressive, and because of that, she had seen no reason to use the GED on him while he was home. She refuted the defense's assumption that she had made use of the JRC's car service in order to transport him home from the JRC for her own protection, and maintained her position that using the GED at home was unnecessary when asked about an incident where the friend of the family had advised that she do so for both her and Andre's protection. She went further still, saying that she had noticed no improvement in his behavior after the GED treatment had begun, even though the JRC staff told her that it was making a difference. In concluding the discussion of the home visit, she testified that she had not told Andre where he was going when she returned him to the JRC, that the one shock he received on the home visit was on the trip back for a behavior that the JRC staff recorded as inappropriate touching of self, which Miss McCollins remembers as him having touched his own leg. Oh my God. The defense also presented Miss McCollins with a number of documents and records of conversations from Andre's placements both at earlier residential programs and at JRC. This included documents based off the complaints she made to Devereaux, documents that included information on how often Andre had been restrained at previous programs, and the various consent forms that she signed for the use of aversives at the JRC. In many cases, Mrs. McCollins could not recall the exact details of the documents nor the surrounding circumstances. She did, however, confirm going over the materials for consent to the use of the GED and other aversives with a member of the JRC staff. Not like they wouldn't mislead her or anything. And knowing that she could contact them with any further questions or concerns she had. In spite of that, she maintained she felt misled, in particular the promotional materials provided to her by the JRC that had made her initially impressed by its program. On brief redirect by Mr. Novotny, Mrs. McCollins stated that her understanding of the consent she was giving for the use of the GED is that she could withdraw her consent any time she wanted, but that this was not respected when it came to her request that the 2 electrodes placed on his arms be removed. In fact, on the 25th of October 2002, Andre was shocked in 5 places, including his arms. Furthermore, when giving her consent, she had not been made aware of the permanent side effects of skin shock, including the kinds that Andre suffered, nor of any of the prior deaths or injuries of students at the JRC. When asked what the goal of Andre's treatment at the JRC was supposed to have been, she answered that it had been to make him more independent by giving the skills he needed, a goal she said was not achieved. Following the end of Mrs. McCollins' testimony, Mr. Novotny offered the video footage of Andre at the JRC, Andre's hospital records after his time at the JRC, and a report on the average lifespan of someone of Andre's demographic into evidence, and rested the plaintiff's case. The jury was read a number of stipulations, namely concerning the fact that Drs. Van Hain and Israel were both employees of the JRC and acting within the scope of their employment at the facility at the time of the incident at issue. The defendants made no motion for a direct verdict, which would have asked the judge to declare them winners by default after the plaintiff had made her case based on the fact that no reasonable jury would have found in her favor, before moving on to the first witness, Dr. Wiley. From talking to reporters from NBC and Fox, it would seem there is a possibility that the news of the trial could be broadcast nationally in the near future. The reporter from Fox stated that the news of the trial were already all over Twitter, suggesting that disability rights advocates and other interested individuals and organizations had been successful in spreading the word. According to Mr. Novotny, the trial will likely reach the end of the next week, given the amount of time of Dr. Whaley's testimony had taken. When asked about the possibility of appeals by either party after the conclusion of the lawsuit, he said that it was unlikely. Specifically, parties can only appeal the outcome of a lawsuit on the matters of law, rather than a jury's interpretation of the facts, and the law on medical malpractice cases in Massachusetts is rather settled. Dr. Riley's testimony beginning on Friday afternoon and continuing into Tuesday, April the 17th, at Ferris State Holiday on Monday will be covered in a subsequent post. So that was a crazy ride, wasn't it? That was completely nuts. I can't think of much I can commentate with at the end of this one. It was rather long, and I was kind of making comments throughout it. So I'm going to just kind of take time to digest it and kind of prepare for the next vid on it tomorrow. That is all we have for today, folks. Now, as always, to close out the day today, we don't get that many views on this channel. The few views that we do get do tend to get removed by YouTube, so please don't forget to hit the like button, hit subscribe, don't forget to hit the comments. I'm going to be including the third part of this trial in the description box, as well as the link to the petition to close down this school. Folks, adversives is not something we should be using in modern society. No matter what the behaviors are, there should never be an excuse to use electro skin shock, food deprivation, sensory deprivation, and to turn going to the bathroom and eating into privileges that you have to earn. Okay? We should not be living in this world in 2021. And that's all I got to say on that. I do appreciate your time this afternoon, and I hope you have a good one. Bye-bye.